What do you recommend to the injured worker who's in that first 28 days and is being treated at, say, the company clinic as opposed to under his primary care physician or her orthopedic specialist?
Well, the worker will know what they'll be aware of the reputation of their clinic. Some company clinics are known as hack jobs, for lack of a better phrase, and they know they won't get the real treatment they need. Some company clinics are quite good, especially in a situation where you as the injured worker don't really trust your clinic. You may want to go to your own treater within the first 28 days, but the employer has no obligation to pay those bills. But wherever you go, it's very important to be sure that you give a full accounting of your complaints. We've had cases where somebody at the time of their injury feels the pain in their neck. There's actually pain elsewhere, say down their arms or maybe their low back, but the one that's really killing them is the low neck. And that is really, and in this example I'm using, let's say that's the only complaint that makes it into the medical records because that's where most of the attention was paid. Well, then later on, the worker says, I'm getting tingling still in my arms and my back, low back still hurts, and the employer or insurer will say, well, you did not complain of that at the time. We don't think that's work related. So it's one of the most important things in workers' compensation, and for that matter in Social Security disability and veterans, is to have a very good paper trail. Make sure that things are getting into the written records that pertain to your case.
This is an issue that I think is very pertinent now because of the advent of electronic medical records. How do you make sure that the medical provider who might be listening to you, in fact, records your complaints, given how difficult that is to accomplish with electronic medical records?
Do you have any suggestions?
Insist.
It's difficult because you really cannot be 100% sure. Now, the patient always has the right to look at the records. They can always ask to review the records at any time. But you really have to stay at it, like you said, especially with electronic, to make sure it's in there. I mean, even to the point of feeling maybe perhaps you're too assertive. But really, you have to take charge of your case and make sure it's in there.
So people know what we're talking about in context of electronic medical records. Often what the medical provider is doing is looking at a template on, say, a tablet, and then filling in specific circles about kinds of complaints. And unlike the past where someone might have listened carefully and then dictated a summary of the story, there's not room for that.
You may be telling a complaint that doesn't fit neatly in one of their boxes, and so it's trying to put a square peg in a round hole. It's your job to make sure it's done. But like you said, Jim, with these forms nowadays that are simply a matter of touching the right buttons to approximate closely to what the person's saying, you might even ask as a patient, if you notice that everything is electronic in your doctor's office, to look at the entry before you leave that day.
And again, that's a careful consideration of whether you become perceived as a difficult patient or not by the medical provider. So it's a complicated equation.
I've always erred on the side of being a pest.
I think that's good advice given the state of the workers' compensation jurisprudence right now. Before we get away from the other benefits, let's cover all three. You talked about vocational rehabilitation benefits. And I know that's far down the field from where we are when we're talking about 28 days after the injury, but why don't you talk about vocational rehabilitation as a further benefit available under the Workers' Compensation Act?
It's sort of the redheaded stepchild, not to offend any redheaded people out there. But actually, you're a little redheaded. Were you red growing up?
Yes.
I thought so. There's a tinge of it. Well, not to offend you, Jim, but people don't think about that third rail a lot of workers' comp benefits. A lot of focus is put on wage loss and medical, but workers' comp does allow for up to 2 years of vocational retraining of vocational benefits. That can be anything that hypothetically could be offered even within your current employer. It could be a seminar, it could be a license or a certification you get. It could be up to 2 years of school. And you just simply have to inform the employer or the insurer that you want that.
However, in my experience, it's difficult to attain, especially the longer durational retraining or education, because the agency contemplates that you're going to be instead more inexpensively returned to the labor market by putting you in light duty work or some short-term retraining rather than a full-blown master's program.
That is, and that can be a viable alternative offered by the employer. There is case law in Michigan about somebody wanting vocational retraining, but the employer having a valid counteroffer of just finding something that you still can do at work. Those kind of cases go both ways though. Just because an employer says, no, we're not going to pay for your retraining, doesn't mean you have to take that as the final answer.
Let's talk about that context of a case, the context in which someone is work-relatedly injured, but the employer says, we can make work for you. We can have you do something else other than your machine's operation work. What's that all about in terms of that kind of response by an employer?
Well, there's duties for both sides after a work injury. One of the duties of the employer is to try to see if there's anything that they can find that you still can do. And that can often be an argument because your employer may not agree with you about what your current abilities are at that point. But assuming that everybody's on the same page, say the employer agrees with your treater's recommendations of a 20-pound lifting restriction, for example, and they're willing to find some job that conforms to that, then the worker does have an obligation to try that job. That's where the duty on the other side comes in. If a viable, real job appears that you can do, either from the employer or arguably from some other place that the employer found out about for you, you would have an obligation to try that. Now, if you try it and you can't do it, that's a lot of times where litigated cases come in because the employer insists on taking a credit for this job they think you can do. You and your doctor say you tried it, you can't do it anymore, and then sometimes you have to let a judge decide.
So how does the injured worker respond if she or he goes back, tries light duty activity, can't do it for a while, can't do it because his medical provider says you shouldn't be doing it anymore, and is off work and the employer won't pay benefits?
Well, and that's where a lot of people get into financial straits. Like I said earlier, the employer has great leeway to dispute a claim until a judge rules in your favor. Assuming a judge rules in your favor, going to trial, you never know how it's going to turn out for sure. But short of a judge's order, a magistrate's order in workers' comp, the employer can say, they'll probably pretty it up more than I'm about to phrase it, but they can say, we're just sick of paying this claim, or we don't like this person too much, and then they'll file notice of dispute, and they probably will put more official language in there. Often they get a medical examiner of their choosing to say that you're not disabled anymore, or you're not as disabled as you say you are. And then on the basis of that medical report, they can file a dispute too.
So it's not only the case in which someone says, I can't do the light duty work, and the employer says, yes, you can, that causes disputes, but it's also the case in which your doctor, if you're the injured worker, says you can't do the job, and the insurer's doctor says, yes, you can do the job. Under either of those scenarios, the injured worker then has to file suit in the workers' comp agency.
Yes, and there's so many variables. We are generalizing because we have to, but I mean, some employers are very pro-employee, and when you go back to them and say, hey, I tried that light duty job for a week, I just can't do it, they may say okay, and it's possible that they'd say, well, then we'll just start paying your benefits again. I mean, there's a whole bunch of possibilities, but what often happens is that there gets to a point where you have a standoff between the employer's doctor and your treater, and then often you do have to go to trial.